All right, still with me, appellate attorney Matthew Barhoma. Matthew, the prosecution wants to paint this as a very simple case. It's basically someone who had too much to drink. They showed you her drinking what amounts to about a six-pack of beer and a shot of alcohol. They show her leaving the place. They see the results of when she left. And it's a very simple case. She killed someone. She had been drinking. It's vehicular homicide by intoxication. Defense has another take on it. They say this was a terrible night. There were all kinds of contributing factors. The dark clothing of the officers. He was in the middle of the road. The barricade that was supposed to show that there was some problem there wasn't working properly, so that there was no light. It was raining. She's 60 years old. She has bad eyes. She was wearing scratched glasses. Is this as simple as the prosecution wants this jury to believe?
No, not in the slightest. There's excellent arguments on both sides of the bench. And what they're trying to get you to do is focus on different portions of the narrative, right? The prosecution's telling you, focus on the incident. A good Samaritan, which is really what they're trying to convict, the fact that maybe she's not a good Samaritan, right, would have stopped. And the defense is telling you otherwise. They're like, no, look at what she's done in the morning. Look at what she's done after the car accident, when she was in her right mind, right, to be able to make a decision after this catastrophic major injury, this catastrophic accident that happened. So really good arguments on both ends. And no, it's not easy for the jury at all. Look at how long they've been deliberating, right? And they're even working through it.
Yeah, it's been 10 hours, and I knew it would take some time. There's a lot to go through. I want to put up some of the charges here just to give a sense of how difficult it really is. You start off with vehicular homicide, right? So that basically is that the defendant killed the alleged victim by the operation of a motor vehicle. Now, the intoxication part is important. Basically, the drugs or alcohol ingested impairs the motorist's ability to safely operate a motor vehicle, or the motorist has a blood alcohol concentration of 0.08% or greater. The punishment for this one is 8 to 30 years. Now, there's another level they can consider. Let's say they get past that. Did she drive recklessly? And that's when a motorist acts recklessly by knowingly doing something that poses a substantial and unjustifiable risk to others. In other words, the person is aware but disregards the risk. And the risk must amount to a gross deviation from the standard of care that a reasonable person would use under circumstances. Punishment here, 3 to 15 years. And then finally, let's say they don't see that. Then they get to criminal negligence. That's when the person ought to be aware of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that the ordinary person would exercise under all the circumstances as it's viewed from the accused person's standpoint. Punishment here, only 1 to 6 years. So Matthew, I ask you, I think her actions that night really can fit into any one of those definitions. And so I can see where the difficulty is for this jury. Very different penalties, but I think it's a difficult choice for this jury.
It's a difficult choice, and let me tell you something. It's also a difficult choice for the DA, okay? This is what I call all but the kitchen sink. All right, they really could have just brought 1 to 2 charges that they really could hone her in on. All right, if you really believed in your case for vehicular manslaughter or vehicular homicide, that would have been charge number 1, and then there would have been 1 more, and that's it. But clearly, I mean, even the DA in coming at her didn't exactly know how to do it, and they made a really good point in closing. They said, listen, she deprived us of our ability to get the evidence, okay? She was sitting on the evidence. She knew she was drunk. She fled. And had we gotten that, we would have gotten her, cold-blooded. But here, that's not the situation, and you could see it in even the way that they brought this complaint, this criminal complaint.
And you know what? I think it was ultimately a net positive for her. Now, she's obviously going to get convicted of one of those charges of leaving the scene of an accident. That holds about, I think, a 1 to 6 year penalty as well. But ultimately, I think it might help her get off on that really tough charge of the 8 to 30 years of the negligent homicide with intoxication. I think that's going to help her a lot, having left the scene. What do you think?
I agree. I agree with you. Listen, there's one criminal act we can totally agree on here. She fled the scene. Okay. Not only that, when you flee a scene, Michael, when you cause a peril, when you're the person who caused this accident and you left someone on the road, you owe them a duty to go back and make sure that they're getting the right kind of medical treatment. And if you neglect that duty, if you deprive them of that duty, that's a criminal act. So yeah, I think unanimously across the board, we could agree the jury might possibly find her guilty on something. But I think the way that she's been charged shows a lack of confidence in the evidence. And if I was the prosecution, I would have came at her a little bit stronger.